and employment law so they can remain in compliance and avoid legal problems from arising in the first place. For Spanish-speaking clients, appreciate our fluency in Spanish when they need services ranging from employee handbooks to witness interviews, et cetera, et cetera. So without further ado, Roxana.
Good morning, Scott, and thank you so much for coming to our office here. Today we're going to talk about leave of absences, concentrating on disabled employees. There's quite a few laws that we need to navigate through in order to be in compliance when we have an employee who is disabled. For example, we have the Family and Medical Leave Act, better known as the FMLA. We have the Americans with Disabilities Act, better known as the ADA. Of course, most states do have their own workers' compensation laws that we need to be aware of, as well as other specific statutes that might apply to your specific state. Pregnant disability leave, paid sick leave. We're here in California, and we are an example of a state that we have our own pregnancy disability leave and our own paid sick leave laws. So the trick here is that when we have a disabled employee is to properly navigate through these laws to be in compliance with all of them, meaning both federal and state law. We have a chart here that we pulled from the EEOC, a chart with different charges filed with the EEOC, and as you can see, we are definitely seeing an increase, excuse me, an increase in disability claims being filed by employees. You can see there that the only two categories that have gone up in filings are retaliation and disability, which generally those two go hand in hand, because an employee will file disability, discrimination, and leave of absence claim, and then along with that they'll file a retaliation claim. So I think it's more important than ever to understand these laws and learn how to navigate through them to be in compliance. So some of the things that we need to consider when we have an employee who is disabled or has suffered some kind of injury. The first one is you need to ask yourself, are the workers' compensation law triggered? Meaning, was this disability or this injury arose from a work-related injury? If that's the case, then you definitely need to start the process with your own workers' compensation law. Is there a separate pregnancy disability leave that applies to you other than FMLA? And by that I mean in your state. Again, in California, we do have our own pregnancy disability leave. Is the FMLA, the leave being requested by the employee, medically related, or is it more associated with the family? Is there a duty to offer a reasonable accommodation? This is where we see most of our clients get into trouble, so we will cover this in more detail later in the presentation. What are the employer's obligations to maintain health coverage or other benefits? There's another area that can be problematic. And does the employer need or have any obligation to designate the leave and send out notices? So these are some of the issues that we're going to cover during the next 15 minutes. So let's start with the FMLA, which is probably the basic one. FMLA stands for the Family and Medical Leave Act. It covers employers must provide up to 12 weeks of unpaid job-protected leave to eligible employees for the following reasons. Before we go into the reasons, let me just point out a couple things here. It provides unpaid leave. This is something very often people believe that it needs to be paid. No, it's 12 weeks of unpaid leave. It is job protected, which means that the employer must hold the job open for the employee. So FMLA applies for the following reasons: incapacity due to pregnancy, prenatal medical care or childbirth. It applies to an employee who needs to take time off to take care of an employee's child after birth, a placement for adoption or foster care, or to take care of an employee's spouse, son, daughter, or parent with a serious health condition. And finally, to take care of the employee's own serious health condition. This is another area that you need to be careful and check your own state laws, because some states will expand those family members that are protected under the FMLA. For example, in California, you also must provide time off to take care of an employee's some stepsons, stepdaughters, and there's the different family members that are including a registered domestic partner. Okay, moving on. What is a serious health condition? That's one of the questions that I get very, very often. So when do we consider a condition a serious health condition? That will include any illness, injury, impairment, or physical or mental condition that involves either an overnight stay in a medical care facility or continuing treatment with a health care provider for a condition that either prevents the employee from performing their job or prevents their qualified family member from participating in school or daily activities. As you can see, there's a lot of elements, a lot of issues there, but you need to, before you understand whether or not you have to comply with the law, you need to understand what a serious health condition is. Continuing treatment, what does that mean? That has its own definition as well. It generally means that it's a period of incapacity of more than 3 consecutive calendar days combined with at least 2 visits to a healthcare provider or 1 visit in a regimen of continuing treatment. It also includes incapacity due to pregnancy and incapacity due to a chronic condition. Now, FMLA leave can be taken intermittently when medically necessary. Where we see this most of the time is when somebody is disabled due to pregnancy. Very often, morning sickness will require an employee take some time off, maybe an hour, 2 hours in the mornings, come in a little bit later in the day because they have a condition that is intermittent. And in that case, we do need to provide a leave on an intermittently basis. But again, it's only when it's medically necessary. And employees must make reasonable efforts to schedule leave for planned medical treatment to not disrupt employers' operations. Now, this is kind of a gray area. Yes, the law does say that they have to make the best efforts, reasonable effort, to try not to disrupt employers' operations. But I always caution our clients that if an employee requires to take time off in the afternoon and they cannot get the treatment after working hours, take a very close look at that and maybe consult with counsel before you deny that time off. Most of the time, they'll probably be entitled to take the time off to receive the treatment. FMLA requires that employees provide 30-day notice when foreseeable, but note the term foreseeable, or otherwise as soon as possible. What does as soon as possible mean? As reasonably possible. There's different terms that will depend on each specific situation. Employees must provide sufficient information for employer to determine if the leave qualifies as FMLA and the anticipated time and duration of leave. So the employee is supposed to bring you information and give you enough information, sufficient information. What is sufficient information? Again, these are vague terms. It will depend on the specific situation to determine whether or not it's FMLA. I generally caution our clients that if you have any indication that this might be an FMLA leave, that you go ahead and start the process just to be on the safe side. There's one of the questions that we get very often. Like I said before, FMLA provides unpaid leave. However, the employee may choose or the employer may require that the employee use any accrued paid leave during the time of the leave, meaning paid vacation, paid sick leave, paid time off, whatever the employer may have. The employee must comply with the employer's normal paid leave policies, which means that if you have a form in place that an employee must submit in order to get paid for sick leave or for PTO, then the employee continues to have the obligation to comply with those procedures. The employer must maintain the employee's health coverage on the same terms. This means that during those 12 weeks that the employee is out on leave, the employer must maintain the health coverage that the employee has on the same terms, which means that if the employee was paying, let's say, for 20% of their premium, the employee still has an obligation to continue to pay the 20% towards the premium. So generally what we recommend is that you meet with the employee and make some kind of arrangement with the employee before they leave on their leave on how that 20% will be paid. Very often employees do not make the 20% payment and then they return after the 12 weeks. I always advise employers not to cancel the coverage because you do have an obligation for that employee to have the health coverage at the time that they come back, and you may have issues reinstating the employee. So if the employee is not making their payments, I will make the 100% premium payment and then deal with that with the employee when he or she returns to work. Now, the FMLA requires that the employee be restored to their original or equivalent position when they return after the 12 weeks. This is the job protection part of the FMLA, which means we need to take all necessary steps to be able to return that employee to their original position or the equivalent position. Now, the equivalent position generally will be another position that has equivalent pay, the same benefits, and the same employment terms. Now, what are the employer's responsibility? We've been covering pretty much primarily the employee's responsibility. Now, the employer must inform employee whether they are eligible for FMLA. So if an employee comes to the office and says, I need to take time off for a medical procedure, then the employer has an obligation to let the employee know whether or not they're eligible to take those 12 weeks under the FMLA. If the employee is eligible, then the employer should give the employee a notice, and that notice should include the rights and responsibilities of the employees. If the employee is not eligible, and we will cover eligibility in a few minutes, a little bit later in this presentation, then the employer must provide the reason why the employee is not eligible. Now, one of the big mistakes that we see with our clients excuse me, is that once they provide the 12 weeks under the FMLA of leave of absence, then if the employee does not return or is not able to return to work after the 12 weeks, the employer will go ahead and terminate the employee. Well, this creates serious problems for the employers, and that what takes us into the ADA, and we will talk about how the FMLA overlaps with the ADA. So we'll come back to this topic in a few seconds. So a couple things to remember, some issues that we've seen with our clients. An employer should not discourage an employee from using FMLA leave. That is a right that the employee has. The way we see this is maybe somebody says, I need 12 weeks off to have some surgery. The employer says, or the supervisor says, well, can you delay your surgery until early next year because this is our busy time coming up during the holidays. That could create a problem from the employer. Remember that this is a right that the employees have, so we should not discourage them from using FMLA leave when they need it or when they believe is the best time for them to take it. Mischaracterizing leave. If it's an FMLA leave, it should be characterized as an FMLA leave, not as a ADA leave or some other or reasonable accommodation leave at this point. We need to be careful that we characterize the leave with the proper name. Entitled to medical diagnosis, this is an interesting issue because there are some forms on the federal website that can be used when an employee goes out on FMLA leave. And those forms that do require a medical diagnosis. Under federal law, that's not so much an issue. However, there are many states that prohibit employers from asking for a medical diagnosis. So make sure that you check with your state laws, if you have any, to make sure that they do not preclude you from requesting a medical diagnosis. And if they do, be careful that when you use the FMLA forms, you cross out that section or somehow make it clear that you do not want to receive that information and you're not requiring that information from the employee. Failing to send out appropriate forms and notices. Very often I get clients who said, yes, I have an employee that went out on FMLA. They told me about it. I put it on my books, but it was never anything in writing that was sent out to the employee. And then the employee says, oh, no, the leave that I took was not FMLA, it was a personal leave. So make sure that you have a system in place with the proper forms that allows you to comply with the notice requirements of the FMLA and also protects you that the leave has been properly characterized as an FMLA leave. So moving on to the ADA. Okay, so we have talked about the Family Medical Leave Act. That's a law that provides a leave of absence either for disabled employees or to take care of a family member. Now, we also have the Americans with Disabilities Act. This law prohibits discrimination, harassment, and retaliation on the basis of a disability. This law also requires that an employer make a reasonable accommodation to enable a disabled individual to perform the essential functions of the job. And we're going to go through some of these terms here because the terms are important. The ADA does not provide job security when you compare it with the FMLA, at least not in all situations. Now, you may have a state law, like we do in California, that imposes a higher burden on the employer as far as job protection under the disability laws. So, first of all, you may note here that we're talking about a disabled individual. Okay, the ADA applies to an individual who is disabled. Well, what is a disability? It's not just having the flu or having a cold or missing a day of work. A disability is a physical or mental impairment that substantially limits one or more major life activities. Now, again, this is where you need to also check your state laws. Some state laws do have a broader definition of a disability, including California, but for these purposes, it's a physical or mental impairment that substantially limits one or more major life activities. Or can be an individual with a record of such an impairment, meaning that they're not disabled at this time, but they do have a record of a disability, or somebody who's being regarded as having such an impairment, meaning somebody who's not currently disabled under the law, but the employer regards the employee as being disabled and treats him in a different manner. All those are situations where disability can be an issue. Now remember, disability is broadly construed, even under federal law. It doesn't take much to fall under the definition of being a disabled employee. Now, it also has to be a qualified individual in order to be protected under the ADA. What does that mean? A qualified individual is an individual with a disability who's able to perform the essential duties of the job with or without reasonable accommodation. This means that if a disabled employee is not able to perform the essential duties of the job, even if you provide him with an accommodation, then that employee is not protected under the ADA. Okay. Now, under the ADA, a leave of absence, and this is where we see the overlap with FMLA, is a recognized reasonable accommodation that needs to be provided to the employee. So, in other words, the ADA steps in, provides a leave of absence in situations where the FMLA no longer applies or doesn't apply at all. The ADA provides that an employer must provide a reasonable accommodation for the known physical or mental disability of an applicant or employee unless it will create an undue hardship. Something to notice here that the ADA applies not only to employees but applicants as well. Now, who has the burden? The employee usually has the burden of giving the employer some kind of notice of a disability, unless it is something that the employer can observe and they can see that the person is disabled. But on a general basis, the employee is the one who needs to come to the employer and let him know that he's suffering of a disability. Now, the employer has the burden to take all those necessary steps to accommodate the employee's limitations, unless the employer can show that in order to accommodate the limitations would create an undue hardship on the employer. And then the employee has a duty to cooperate with the employer efforts by explaining his or her disability and qualifications for the job. So what this means is that there's burdens on both sides, on the employer and the employer, and this is all part of what we call the interactive process. Now, how do we deal with reasonable accommodations? A reasonable accommodation, the goal is to find the best match between the employee's capabilities in an available position. The ADA does not obligate an employer to choose the best accommodation or the specific accommodation that a disabled employer or applicant seeks, meaning that if an employee says, well, I am disabled, I need a reasonable accommodation, I cannot perform the essential functions of my job, but I think I can perform the essential jobs of that position over there, and that's the accommodation that I want, well, the employer does not have to comply with that. It's not up to the employee. The employer has an obligation to engage in the interactive process. It has an obligation to look into all possibilities and make an assessment, but at the end, the employer is the one who has the final say. The accommodation must be reasonable, meaning that what that means is going to depend on the size of the employer, the type of business, the positions available at the time, and different other considerations. So what is reasonable, in other words, will change depending on the nature of the employer. Some examples of a reasonable accommodation: it can be job restructuring, could be part-time work, modified work, reassignment to a vacant position or another location, a temporary leave of absence. We'll talk a little bit more about this. The use of equipment or special devices. Pretty much a reasonable accommodation can be anything under the sky as long as it's reasonable. Okay, so here we're going back a little bit as to when is an employee eligible for FMLA. Remember that we talked about eligibility. In order for an employee to be entitled to leave under the FMLA, he has to be an eligible employee, meaning that he has to have been employed by the covered employer for at least 12 months. What do we mean by a covered employer? The employer has to employ more than 50 people. So if an employer has only 15 employees, then the FMLA would not apply and the employee is not eligible for FMLA leave. The employee has to have had at least 1,250 hours of service during the 12-month period immediately before the leave started, and have to be employed at a work site where the employer employs 50 or more employees within 75 miles. So as you can see, these are the requirements for somebody to be an eligible employee under the FMLA. If the employer has less than 50 employees, then that employee will not be entitled to FMLA. If the employee has only been employed for 2 months, or the employee has now worked at least 1,250 hours, then again, that employee will not be eligible under the FMLA. Now, the ADA has no such requirements. The ADA talks about a qualified employee with a disability. Those are the requirements to be protected under the ADA. The employer can have less than 50 employees, but must have more than at least 15 employees in order for the ADA to apply. The employee doesn't have to work for 12 months in order to fall under the protection of the ADA. And the employee does not have to work for 1,250 hours in order to be protected under the ADA. Also, the ADA will come into play if an employee is eligible for FMLA and has used the 12 weeks provided under the FMLA and has exhausted those 12 weeks. In that situation, now again, the ADA will play a role and would apply to that employee. The only basis to deny a leave of absence as a reasonable accommodation under the ADA is for the employer to show that that reasonable accommodation will cause an undue hardship. So a qualified individual with a disability is entitled to additional leave time beyond the 12 weeks permitted under the FMLA, as long as the additional leave does not cause an undue hardship on the employer. The ADA, and this is something that employers very often don't understand and get confused with this, the ADA operates independently of the FMLA. Very often I see notices of a leave of absence that characterize the leave both as FMLA and ADA. So remember that they operate independently one from the other. When an employee requests time off for a reason related or possibly related to a disability, the employee should consider the employee's leave entitlement rights under both the FMLA and ADA. The employer is also required to initiate what we call the interactive process to determine what reasonable accommodation, if any, are needed. So anytime an employee comes into your office and says, I need a leave of absence, I'm disabled, I need some time off, then you need to go ahead and consider both the FMLA and ADA, how they apply to this one specific employee, and also it's very important that you remember to initiate the interactive process if necessary. Since they operate independently of each other, the employer must therefore provide leave under whichever statutory provision provides the greater rights to the employee. This is something, a good rule to remember across the board in employment law, because we do have overlapping federal and state law. Whenever you have both laws, or even two federal laws that overlap with each other, always provide whatever gives the employer the greater protection. For example, in this case where we talk about FMLA versus ADA, although the FMLA permits the employer to place an employee returning from a covered leave, meaning from a 12-week leave of absence, in an equivalent position, the ADA requires that the person returning from that leave will return to her original position, which, as you can see, it's a higher standard. Therefore, an employee covered by both statutes, if you have an employee who falls under the FMLA and the ADA, then you need to return that employee to his or her original position once they return. Again, unless you can show undue hardship. Job reassignments. Typically, these are sought when there are no reasonable accommodations that permit the injured employee to perform the essential functions of his or her job. So we have determined already that this employee is a qualified employee, is a disabled employee. We have begun an interactive process, and we have determined that this employee cannot perform the essential functions of the job, even with an accommodation. So this is when we go and look at other options. Can we reassign the employee? Can we transfer the employee? But when we do that, we still need to consider whether or not that employee is still qualified or has the qualifications to perform that other position. Can the employee, is the employee able to perform the essential functions of that new position or different position, I should say, that we are considering? There's a recent EEOC case that indicates that an employer may have to reassign the disabled employee despite having other candidates with better qualifications. So this is an area you may want to consult with legal counsel before you make a final decision. But remember that if the employee is entitled to a reasonable accommodation under the ADA but cannot perform the essential functions of his job, then you need to look into other positions, other possibilities, other options, but that employee still needs to be able to perform the essential jobs of that different position. To be protected, the individual, to be protected under the ADA, the employee must be qualified to do their job. This means that the employer is not required to create a new job. There's no requirement. Actually, be very careful doing that, because if you do create a new job for an employee who's disabled, you may be required to create a new one for all subsequent employees who are disabled. So you don't want to establish a precedent. There's no requirement that you create a new job. You don't need to move an employee to accommodate this employee who's disabled. The employer is not required to promote the disabled employee to another position. An employer does not have to violate another employee's rights in order to accommodate a disabled employee. The duty is to reassign a disabled employee, and she's really a qualified disabled employee, if an already funded vacant position at the same level exists or one will become available in the foreseeable future. Although an employer is not obligated to compensate an employee at the same rate of pay, if they're moved to a lower paid position, as an accommodation, it will be a good idea to try, if at all possible, to remain at the same salary to avoid having a retaliation claim. So if I always advise our clients, if you can maintain the same level of compensation, you should do that in order to avoid any retaliation claims. Okay, so talking about the interactive process, I've mentioned that a couple times. So when you have an employee who is disabled and they need an accommodation in order to perform the essential functions of the job, you need to engage in this process. And it's really, the burden is really on the employer to do this as soon as possible. Don't put it off. It's important that right away you start to engage in the interactive process with the employee in order to explore what reasonable accommodations, if any, are available to that employee that would allow him to perform the essential jobs of his job or some other job at the facility. The law is very clear that it requires a timely, good faith interactive process, and there's quite an amount of litigation with these terms, whether they're in good faith, whether they're timely. It's preferable that you meet with the employee in person. Sometimes the employees are out on disability and they're not at a location where you can meet with them face to face, and you may have to do this on the phone. But if at all possible, it's better to meet with the employee in person. Interview others to find out what other positions are out there available for this employee. Obtain any necessary medical information. If you have questions about what kind of duties the employee who's disabled can perform, then you have the right to communicate with the medical provider, maybe send a list of the job requirements of the specific position you're considering, and asking the medical provider to let you know whether or not the employee can perform the essential functions of that job. Complete any necessary forms, reports, claims, and document your file. Documentation is key. Very often employers will meet with employees, will have these discussions, but there's no documentation to show that the meeting took place, and this becomes a problem later on when somebody claims that the employer did not engage in the interactive process. Now, under some jurisdictions, including California, an employee can have a separate cause of action for the failure to engage in the interactive process. So this really, the documentation is really an important aspect of this process. Make sure your company policies are updated. Use your policies when you meet with the employee concerning the interactive process. Make sure you comply with the law. Again, make sure you comply with federal and state law. And make sure that you apply the interactive process consistently with all your disabled employees. This takes me back to what I said a few minutes ago. I've seen situations where an employer would create a new position for a disabled employee because that employee happens to be a really good employee they want to keep, or is one of their favorite employees, but they won't do it with another employee who's disabled. Again, you can create precedents if you do not treat all your disabled employees equally, if you do not engage in the same type of interactive process with all your disabled employees. This is a situation where job descriptions are important. If you have them, make sure that you use them. You want to go through the job description with the employee to determine what duties he can perform and which duties he cannot perform. And that way, you can first determine whether he can perform the essential jobs, functions of the job, or whether you need to look into other job descriptions or other job categories to accommodate the employee. Other things to keep in mind: do not disparage or discriminate against an employee. Excuse me. Examine all reasonable accommodations. Sometimes you may have to look at other locations. Do we have a position for this employee at a different location, in a different state, in a different county, and things like that. Stay in contact with the employee. So let's say that you go through the interactive process and you determine that you cannot accommodate the employee. There's no accommodation available for that employee to continue working. But it's important that you continue to stay in contact with the employee. This is an ongoing duty that the employee has of the interactive process. It's not a one-time thing. So you want to make sure that you continue to receive doctor's notes, certificates from his doctor to see if the condition has changed. If the condition has changed, if the restrictions have changed, then now this is the time to meet with the employee again to go through the entire process again. Well, what are the new restrictions? What are the options that we have? What do we have available? Can we accommodate you? Develop a plan to offer an accommodation. And be prepared to deal with an employee you cannot accommodate. So what do we do with an employee we cannot accommodate? If we feel comfortable that we have explored all options and there's nothing available for that employee and there's no accommodation that allows him to do his job, then unfortunately we need to tell the employee we cannot accommodate you and he's going to be on a leave of absence until his condition changes. This is going back a little more in detail about documenting the process, and this tells you how important it is to document the process. Make sure your documentation shows who was present during the interactive process, who did the interviews, who spoke with the employee, what documents were reviewed with the employee. Did you review the job description? Did you review a prior job assessment? What documents were reviewed with the employee? Medical certificates that were reviewed with the employee. Work restrictions. Make sure if you don't have a job description, make sure that you have a list of essential functions of the job so the communication is clear. List all accommodations that were suggested and consider. You know, the employee suggested these accommodations, we suggested these accommodations, and this is what we determined considering these suggestions. Even the ones that are unreasonable. Even if the employee request something like, I need to work out of my house, but however, you know, they deal with clients. It doesn't matter how unreasonable, go ahead and make sure it's part of your documentation. Any positions that were considered during the discussion, any comments by the employee, you should include in your documentation. And you should have everybody sign the document as well. And keep this form, complete this form every time there's a new restriction provided by the employee that triggers a new interactive process. So I've told you several times that the only time an employer does not have to provide a reasonable accommodation is when that accommodation creates undue hardship. Well, what does undue hardship mean? Again, we have these vague terms in the law, but generally we think of it as requires significant difficulty or expense. So what are the factors that you're going to consider? The employer financial resources, the number of employees that are employed by the employer, the nature of the accommodation being sought, the cost of the accommodation, the impact of the accommodation that it places on the operations of the business. These are just some factors. There are many factors that can be considered, but I can just say that it's difficult to prove undue hardship. So if you're going to take the decision that it will create an undue hardship, make sure that you have documentation to show why you made that determination. The employee only needs to show that a requested accommodation is generally reasonable. Yes, they're not allowed to ask for something that's completely unreasonable, but it just has to be generally reasonable. It is the employer's obligation to demonstrate specifically that a request will create an undue hardship. So in other words, it is the burden of the employer to prove the undue hardship. A leave is more likely to be deemed an undue hardship the more complex the nature of the employee's work, the difficulty to replace the employee, and how difficult it is to distribute the employee's work. Moving on, we're still talking about the ADA. Because the employer has an obligation to assess each requested accommodation on a case-by-case basis, it may not apply a maximum leave policy. Very often we see employers that have a policy in their handbook that says something like An employee may not be absent from work more than 5 months or 6 months, and at that time there will be an automatic termination of employment. Well, as you can see, we have a definite amount of time that the employee can take under the FMLA, and we know those are 12 weeks. But under the reasonable accommodation requirement of the ADA, we don't know how much time the employee can take off as a reasonable accommodation, because again, we're talking about the term reasonable. Now we see different time variations. Some courts have determined that 3 months is reasonable. Others have determined 6 months is reasonable. I generally tell our clients 6 months is definitely reasonable. We do not want to terminate somebody after they take an additional leave of 3 months, because I think at that point they're still entitled to additional time off as a reasonable accommodation. So I would say that anything between 6 months and a year would be considered a reasonable amount of time for somebody to be provided with a leave of absence under the ADA. Another area that employers must be very careful with are the no-fault attendance policy. What I'm referring to is policies that causes employees to accumulate points for being out of work or being absent or being sick for different reasons. Obviously, these point attendance policies should exclude any time that is being taken off under the FMLA or due to a disability. However, very often this causes problems for the employer, because at some point somebody, let's say, took 2 weeks off due to a disability, and then they're right on the verge of meeting the maximum number of points they can have, and then they miss one additional day for other reason, but it's too close to the time that they took off due to the disability. That can cause problems for a retaliation claim. So be very careful with any policies, any attendance policies that provide for termination after a certain number of absences. An employee does not need to show that the leave is certain or even likely, only that it will plausibly enable the employee to return and perform his job. So meaning the employee does not have to bring a doctor's note that says the employee will be able to return to work for sure on December 1st. All it has to say is that it's likely the employee will be able to return to work on a specific date. Now remember that an employer is not required to provide an indefinite leave of absence, meaning that if an employee comes back, let's say they have exhausted the 12 weeks of FMLA, they're still unable to return to work, and they bring a doctor's note that says the employee will be out for an additional month and a half or an additional 2 months, then this is the time that you need to provide the leave of absence as a reasonable accommodation. But if that note says the employee is not able to return to work, and we don't know when the employee is going to be able to return to work, then there's no obligation to provide a leave of absence as a reasonable accommodation, because that will be an indefinite leave of absence. Now, if the employee brings notes every month and a half, every 2 months, saying, I'll be back in 2 months, then that is not considered indefinite, and that needs to be accommodated. And again, at what point, that's the question I get very often. If I'm getting these notes every 3 months, at what point can I stop accommodating the leave of absence? I generally say anywhere between 6 months and a year, depending on the specific circumstances. So you should probably check with legal counsel before you make a determination. Again, a leave of absence under the ADA also can be an intermittent leave of absence or a modified schedule. We talked early on, we mentioned, there's different laws that we need to navigate, the FMLA, the ADA, but of course we also have Pregnancy Disability Leave Act under the federal law that provides protection to a pregnant employee. So pregnancy alone is not considered a disability. So pregnancy alone would not fall under the ADA. In order for to be considered a disability under the ADA, then the person who's pregnant must have some kind of impairment related to the pregnancy, and now they will fall under the ADA. So complications resulting from pregnancy may be impairments that the employer will need to consider and accommodate on a case-by-case basis. An employee is permitted to take FMLA leave if she is incapacitated by pregnancy or after the birth of her child. Very often employees request FMLA leave just because they're pregnant. Well, being pregnant alone will not make the employee eligible for FMLA. They need to have be disabled due to the pregnancy in order to be eligible under FMLA. Similarly, although the ADA does not recognize pregnancy as a disability, we have the Pregnancy Discrimination Act of 1978, and this is important to remember, that makes it illegal for employers to terminate an employee for taking time off due to complications arising out of a pregnancy, even if the employee has exhausted her FMLA entitlement, which means that brings us back to the reasonable accommodation issue. So work-related injuries. Often employers think that because an employee gets injured at work and they are covered by a workers' compensation policy, that they do not need to comply with the other disability or leave of absence laws, and that is a big mistake. If an employee suffers a work-related injury, of course, you need to comply with your workers' compensation requirements, which generally requires that you give them a claim form. And then that puts the employer in notice that there's a potential work-related injury. Most of the time, your obligation is only to give them the form. After that, the form gets submitted to the workers' comp carrier, and the workers' comp carrier will take care of the rest. However, at the same time that you do that, you need to evaluate whether or not the employee is also eligible under the FMLA. And if the employee is, if it meets all the requirements, having worked so many hours, 12 months before, et cetera, then you also need to provide the employee with notice that he's being placed on FMLA. So in other words, very often the workers' comp claim will run concurrently with the FMLA leave of absence. Now, once the FMLA has expired, again, if the employee is still disabled due to the work-related injury, then the employer needs to start the process concerning the interactive process and exploring any reasonable accommodations that would apply. So in other words, all the provisions of the FMLA and the ADA will apply to an employee who suffers an injury at work the same way to a disabled employee. And I think that was the end of our presentation.
Yes, so Roxana, great information, and I've seen these slides before, and it boggles my mind as to how complex it is. I don't know how payroll professionals and HR professionals can take all this stuff in. So if you've got some questions, we've got 6-7 minutes left to be able to answer them. So go ahead and use the questions box on the webinar. We get a ton of questions, but feel free to ask them. And if we exceed our time limit, then we'll make sure that if you visit our website, we'll have all the questions and the answers listed there. Or feel free to talk to Roxana as well. So Novatime is a sponsor of this webinar. You may kind of try to figure out why a time and attendance company with software and services can help with this area. So Novatime has added, we've always had the ability to have employees request time off from their employer through the system, and to automate that and make it fair and consistent with all the employee base, regardless of where they're located and what their jobs are. We've added the ability to do an FMLA leave request and really advance the capabilities of the system to be able to accommodate that. As Roxana said, there's a lot of documents and interaction and notes and forms and things that need to be filled out and kept up to date. And this is exactly what we're talking about. So, we keep track of people's time, so the ability to track the service months and the work hours and the balance of leave, if it exists, and whether or not they're eligible or not to claim FMLA is in the system, and that's typically a function of a time and attendance system. So you can see here the person is requesting, the employee is requesting some time off with FMLA, and based on the rules and regulations that we've taken, they are eligible. So For the employees, they've got the ability to do an FMLA request and validate that. There's on-screen compliance form entry. For the employer or the administrator, there is a very detailed configurable workflow and to-do list. Reminders sent via an automated system, a notification system within the Novatime system, and then the ability to tie it into a calendar and some reporting analytics and integration with other systems and things as well. So it's really a great system. So talking about the documents and things, there's so many documents that are out there. So having those documents in the system with the ability for the employee to have access to them on their own is a great thing. So I can pull up this certification of healthcare provider serious condition form. I can fill it out. I can sign it. I can save it. I can print it. And then by doing that and going through the workflow that exists, gives both me and the employer administrator all the information they need to properly take care of the case. When I talk to customers and prospects about this kind of thing, they're pretty excited about it because typically tracking leave and specifically intermittent leave is a highly manual process, and I've seen endless 4-6 inch 3-ring binders with paper pulled out and shuffled back in, and then wall calendars filled with dates and the people in payroll and HR getting up and down and back and forth and crossing out and putting that, and it's just a nightmare. And there's a liability to that as well if you're doing it incorrectly. So Novatime can help by having the questionnaires, having the to-do lists, having the dates, all the forms there, the notifications and reminders, and really makes it a lot easier for you. So let's see. Okay, so a couple minutes left. At the end of the webinar, we're going to send out 2 emails, like I said before. One's going to have the slides, so you can grab those yourself, and the other one is going to have the certification. You can get on our website, www.novatime.com, and gather the information as well, and also keep up to date with some of the additional webinars we're having between now and the end of the year and then next year. So let's see, downloading slides. This is a screen. As I go through the questions, I want to leave this up. So Roxana's information is on the left, and she would love to hear from you. She can, she's got experience, and she can give her experience and talk to you about the specific cases and things like that. So here's her email and her phone number. For Novatime, if you've got questions regarding the system you've already got with Novatime or becoming a new customer, then give me a ring or a phone call at the numbers on the right. So leaving that up right now, and I got a couple minutes. Some of the questions I've got, let's see. Question to you, Roxana, does marriage counseling apply if it impacts their ability to perform their job? Depression, anxiety, et cetera, et cetera.
Yes, it does. It definitely does. It does include mental conditions. So if they have a doctor's note from a marriage counselor, most likely it would qualify as a proper note to give them the time off or to be disabled or to start the interactive process.
Okay, great. Another question here regarding benefits. In regards to benefits, if an employee has not submitted their portion of their premium while on their FMLA leave, you've indicated that we safe that we continue their coverage until they return. What if they do not return? Can we terminate their benefits retroactive